Okay, so the Constitution, there are various things in the slides. I'm not going to go over all of them. There's a review of the Declaration of Independence and Federalist 10 and 51. I'm not going to go over those review points because you can just watch the videos again whenever you'd like. There's some historical background, which is useful. Your textbook has a good discussion of a lot of that. I'm not going to go over that in this lecture. I'll jump to the Articles of Confederation. Okay, so this was the first Constitution that the United States had. And so basically, again, let's talk about a little bit about the timeline, what happened. Declaration of Independence, again, articulates a lot of the fundamental political ideals and some of the underlying principles of what government should be, what human nature is, things like that, which have tremendous influence on the Constitution to some extent, and even more in some ways on American self-identity, on American political culture, self-understanding, things like that, but does not have any legal standing, or it's not legally binding now like the Constitution is. Okay, so the Declaration of Independence is written in 1776. There is a war with Great Britain. The American colonies win, become an independent country, and their first constitution is the Articles of Confederation, okay? And that was basically sort of like an overreaction to their experience under the British and the king in particular, okay? So they're very concerned about the articles about the possibility of government abuse, about things that happened with the king. So remember, we know that the king was the executive. He did various things that had too much power. Some of the concerns and the specific criticisms in the Declaration of Independence had to do with the king or the executive taking away power from other branches of government, or trying to, largely successfully. And therefore they thought trying to drive towards becoming a tyrant, okay? So the Articles of Confederation created a very weak national government to try to prevent tyranny or the loss of rights or freedom. Okay, there was no executive branch at all. So rather than trying to tame the executive or trying to make the executive accountable to the other branches or anything like that, there was just no executive whatsoever. There was no president, nothing. There was a Congress, but Congress was relatively weak. It was a lot of the ways in which it was weak, especially compared to what Congress became under the Constitution, was in economic matters. It couldn't really collect taxes, couldn't pay for defense or debts. I mean, a colorful story, it was once sort of chased out of Philadelphia, which was the national capital at the time, by members of the Continental Army whom they couldn't pay because they didn't have the money. But they couldn't really do much to regulate the economy. And some of the issues that the country had, some of these little rebellions, had in part to do with a very unstable and weak economy, which the Federalists argued had a lot to do with the fact that Congress could not efficiently or effectively regulate the economy or any kind of economic matters among the various states, okay? So Congress was weak, couldn't collect taxes, couldn't do a lot of things. There was no national judiciary. There was no court system, which of course we saw Brutus was very worried about when the Constitution created that. One of the big issues here was there was no way then to adjudicate conflicts between the states, okay? So if two states had a conflict over borders, over commerce, whatever it might be, there was no way to decide. There was no objective third party, and certainly none with actual constitutional or legal authority to tell them, okay, here's the decision. Now this dispute is over, it's been resolved. So these disputes then could lead to tension and concern sometimes that eventually this could lead to military conflict between the states, which is one of the things that the Federalists were very worried about. The Anti-Federalists less so, but one of the things that the Federalists argued for when they were arguing for the Constitution is we need a way to adjudicate these disputes, these conflicts between the states. Otherwise, we could end up with an arms race between the states. We could end up with war or some sort of armed conflict between the states, or we could end up with some states drifting into the sphere of some of the other colonial powers that had major holdings in North America, Great Britain, also France, Spain at this point. So there were a lot of concerns about that the Federalists had about the inability of the Articles of Confederation to really maintain order among the states and all the problems that they saw arising from that, okay? Again, Congress under the Articles of Confederation couldn't regulate commerce either nationally or internationally. Individual states started making their own treaties with foreign governments. They also started coining their own money. So largely, or in many cases, you had states effectively as single economic actors. They would coin their own money, they would make their own treaties with other governments, And that created all kinds of problems, obviously for national sovereignty, for the Congress doing it, why do you even have a national government? But it also created problems because, again, it created a very unstable patchwork of little economies across the country. Each state being its own economic thing left them prey to much, much greater instability. And so one of the things that happens in the Constitution is Congress is very explicitly given the power to regulate commerce, okay, in the hopes of obviously making that more secure. So those are some of the features of the Articles of Confederation, okay? Constitutional Convention, in a way, we've been talking about the Constitution the entire class so far, and we will continue to in many ways. So I won't go over every detail of the Constitution for obvious reasons, or again, every historical detail of the Constitutional Convention, because that's not really the point here, okay? Representation in Congress, though, one of the major disputes or debates at the Constitutional Convention that obviously had massive implications for the way that the Constitution and the US federal government was created, okay? Representation in Congress, what should it be? Should it be equal for all states, or should it be based on population? The democratic thing, students sometimes say, well, what would be democratic is for it to be equal by states. That way it's all equal, but remember, well, you're representing people, not states, except of course to some extent you are representing states. In the Senate, where representation is equal for each state has 2 senators, you effectively are representing states. So Wyoming and California have the same number of senators, Texas and Rhode Island, so on and so forth. But ideally, you're representing not really states, but individuals, people. So the more democratic thing would be to base representation on population, so that a state with 1 million people has more representatives than a state with 100,000 people. But because, again, as we talked about, the states were there, and the founders, when they were writing the Constitution, when they were designing the Constitution and the government, they had to deal with the fact that the states were there, and with the fact that the Anti-Federalists thought the states would better protect individual rights and better protect their interests. So they basically had to make accommodations for the various states, for their existence, for their interest, for the fact that the states were a major instrument through which a lot of people, especially the Anti-Federalists, thought that their interests would be protected, expressed, achieved, okay? So basically the New Jersey plan, smaller states like New Jersey, equal representation for all states. The Virginia plan, on the other hand, Virginia was a larger state in terms of size and especially in terms of population. The Virginia plan was representation should be proportional to population. It should be based on the number of people, on population. More populous states should have more representatives, okay? That was the Virginia plan. Then you have the Connecticut Compromise, which is what we got. A upper house, a Senate, in which representation will be equal for every state. Okay, and then a lower house, the House of Representatives, where representation will be based on population. And this obviously gives the smaller states more power. First of all, any kind of power sharing like that, but especially because the Senate, as we know, in many ways has more important powers than the House. The ability to, the Senate has to ratify treaties and also has to confirm presidential appointments to the executive branch and to the federal judiciary. So the small states end up with a lot of power, in part because any kind of any amount of giving equal representation for all states gives them more power, but especially when it's the Senate in which that happens. The small states then have a lot of power. So today the smaller states, Wyoming, the Dakotas, Alaska, Vermont, I think is one of the least populous ones. Those states have a lot of power relative to their population, okay? So that's representation in Congress. Again, remember for the test, for things like that, how is representation in Congress determined? You don't necessarily have to remember the Constitutional Convention or the Connecticut Compromise or these other plans. Do know, because this is obviously important, in the Senate, representation is equal for each state. In the House of Representatives, representation is based on population. Okay. Some other issues with the Constitution. Slavery was debated somewhat. Again, there was a certain amount of acceptance that they were going to have to let it go. There was the infamous 3/5 compromise, which is that 3/5 of all other peoples. There was no direct mention of slavery in the Constitution. Some of the opponents of slavery around the time of the Civil War and afterwards later interpreted that as very intentional, that the founders did not want slavery mentioned, and therefore they didn't want to seem to be countenancing or allowing or accepting it as something that should be in the Constitution or should be accepted as good or permanent part of the constitutional order. But it was allowed. It obviously wasn't abolished. The 3/5 compromise, sometimes said that, you know, that's like they counted for 3/5 of a person. It's actually, frankly, much worse than that. Of course, slaves had no political rights. They didn't have 3/5 of the political rights of other people. They had none whatsoever. So the 3/5 compromise was about determining how much of the slave population should count for representation in Congress, okay? And they came up with 3/5, okay? Adult male suffrage, should all adult men be able to vote? That was kind of the more progressive thing that could have happened, okay? Abolishing slavery in the Constitution, that was probably never going to happen, and everybody understood that. Giving women the right to vote, we look back now and that's obviously, you know, stands out, but nobody really had that idea at the time. The sort of progressive thing that people were thinking about that could possibly have happened would be to give to all free adult men the right to vote, and that was left to the states. So they kind of backed off on even that. That was too controversial. Okay, Congress again is granted many economic powers for the reasons that we said. And then the creation of federalism, okay, a new system of government that didn't really exist until the United States created it out of necessity. So you have a federal government and then you have state governments and they share power. We're gonna have a whole unit on federalism. So we'll talk about what federalism is a lot more. But they create federalism in which you have a national or a federal government and you have independent state governments and they share power. And again, when we talk about federalism, we'll talk about how the cooperation or the non-cooperation, the balance of power between those two levels of government has changed over time, okay? But the Constitution creates this new form of government, federalism. Kind of a little bit there with the Articles of Confederation, but now you have a much more powerful, dynamic, extensive national government, which is still sharing power with the states, okay? And one of the keys to federalism is both levels of government have a constitutional basis and both derive their powers directly from the people. So it's not that the states exist as units to express the federal policy or vice versa. Each has a direct basis of power, legitimacy, constitutional standing directly in the people who are the source of authority, obviously. So federalism is created by the Constitution. Okay, individual rights, I'm gonna go over this somewhat quickly, okay? We have a discussion of this, civil liberties, a little bit later. Habeas corpus, the Constitution, the original Constitution does prohibit the suspension of the right of the writ of habeas corpus, okay? Habeas corpus, writ of habeas corpus, basically means that when you arrest somebody, when the government arrests somebody, they have to bring them to court and bring them before a judge and explain why they've been arrested, okay? They don't have to have the trial immediately, but habeas corpus basically means that the government can't come out and arrest you and hold you and not explain to anybody why. Okay, so obviously you're concerned about individual rights, if you're concerned about the government having too much power, if you're concerned about the government possibly using that power to crack down, to suppress dissent, the first step, and the Anti-Federalists definitely thought this was only the first step, but the first step would be making it so that the government cannot just arrest people and hold them with no explanation as to why, okay? So habeas corpus, Latin, literally means something like produce the body. The notion is when the government arrests you, they have to take you to court, bring you before a judge, and explain what you've been arrested for, okay? A lot more protections come in with the Bill of Rights, okay? Because obviously arresting you, bringing you in, saying we've arrested him for whatever, and then just holding you indefinitely, that would also not be good. But habeas corpus, they have to say why. They cannot arrest you and hold you without explaining why or without, you know, bringing you into the court system to some extent, okay? Other things, Congress, both Congress and the states are prohibited from punishing someone without a judicial trial or for acts that were not illegal when they were committed. Okay, mentions trial by jury, very specific definitions of treason, prohibits the imposition of religious qualifications for holding federal government positions. So it says, you know, you cannot impose or require some sort of religious qualification for somebody to hold a federal government position, but that's a very minor, or not minor, but that's a relatively restricted or weak version of what you get in the Bill of Rights with the First Amendment. where Congress is prohibited from interfering with religion itself, okay? So in the original body of the Constitution just says you can't have a religious qualification or a religious requirement for holding federal government positions, okay? First Amendment gives much broader and more robust protections for religious liberty, okay? So there's a meme, Articles of Confederation, original Constitution, then the Constitution with the Bill of Rights. But the opponents of the Constitution, the anti-federalists, thought these measures were clearly inefficient. They wanted a Bill of Rights. They wanted a much fuller, more detailed listing of individual rights, protections, limitations of government power. The Federalists, one of the concerns was that you don't want to start listing rights because that kind of implies that people get their rights from the Constitution, rather than the Federalists were arguing we should see the Constitution as these are the powers that the people give the government. We don't get our rights from the Constitution. We have our rights by nature, and then we give certain powers to the government, and we should be very clear what those are, and we shouldn't think that there are any more beyond that, any more powers that we're giving them. Although, as we've seen, necessary and proper clause means that the government will do new things and will expand its power in some ways. But the concern was you don't want to make a list of rights, because if you forget one, somebody will come along and say, well, that's not in the Constitution, so you don't have that right. That's why you have the 9th Amendment, which says that in addition to the previous 8 amendments, which list really important civil liberties, really important personal liberties, the fact that those are listed doesn't mean that there aren't other rights that people have. They do. And those rights are no less important, okay? So we'll talk about that a little bit more when we talk about civil liberties and the Bill of Rights. But one of the issues there was that the the Federalists sometimes thought, you don't need to worry about it. This Constitution is so well designed, you don't need to worry about the government abusing its power. But there was also some real resistance to a Bill of Rights, because they thought, again, you don't want to list the rights. You want to assume that people have all the rights. You list the powers that they're granting the government. But the Anti-Federalists, of course, it was kind of hard to believe that, given that there were some of these things like habeas corpus and some of the other things we just talked about. There clearly were some specific civil liberties, some specific rights, some specific protections or restrictions on government power listed in that original Constitution. So that was one of the reasons why the Anti-Federalists weren't persuaded. And again, most state constitutions had bills of rights, so they insisted on it. With the Bill of Rights, the states did ratify it, okay? And again, we'll talk about that much more when we talk about civil liberties, okay? So the Constitution, how does it change over time? So that original Constitution was ratified in the 1780s. How do you change it, if at all, okay? There are 2 processes for formally amending the Constitution, okay? One of them is very rarely used. So there are 2 ways to propose, 2 ways to ratify an amendment. So an amendment is an actual formal change, a new document that is added to the Constitution, like the 13th Amendment, which abolished slavery. So, you know, the First Amendment, which says, you know, Congress can't pass laws regarding religion and so on. So an amendment is something that obviously the first 10 were added right away. 14th Amendment says all people have citizenship, and they are all citizens of the national government, and the states cannot interfere with their rights that they have as citizens of the national government. Okay, 19th Amendment gives women the right to vote. Okay, so those are, an amendment is usually, well, it can be longer or shorter, but it's an actual piece of text that is added to the Constitution and then becomes part of the Constitution. And now you know, okay, slavery is not permitted. Women can vote. Nobody can produce or sell alcohol. Never mind, they can again. You know, these amendments are things that, you know, senators are going to be directly elected by the people now. The federal government now has the power to collect an income tax. These are things that are added to the Constitution, very clear, very direct, okay? How does that happen? Well, the first step is to propose the amendment, and then the amendment has to be ratified, okay? And in very simple terms, amendments are proposed by Congress and then they're ratified by the states, okay? President and the judiciary, the court system, they have no role in amending the Constitution at all, okay? So how do you propose an amendment? Congress proposes it by a 2/3 vote in each house, okay? So you have to get 67% of the House and of the Senate to vote to propose an amendment. You can also have a national convention called by Congress, which can propose an amendment. this has never happened. So we don't really need to worry about this in terms of something. It can happen. You can have a national convention. You can have an amendment. You can propose an amendment that's been requested by 2/3 of the states. Not really a very live option, but what has happened, again, begins with Congress, okay? 2/3 in each house has to propose an amendment. And it may not sound like that much, but again, two houses, 2/3 vote, that's a pretty big majority. So that's fairly difficult just to get started, okay? So again, how does it get ratified? How does it actually get adopted as part of the Constitution? Again, two methods. You can have special state conventions. That's pretty rare. Usually legislatures in 3/4 of the states will ratify, okay? So basically, make it really simple, okay? Amendments to be proposed, even to be seriously considered, to be proposed, they have to be proposed by a 2/3 vote in each house of Congress. And then to be ratified, they have to be ratified by 3/4 of the states. Occasionally, maybe by special conventions, usually by the state legislatures, okay? So first 10 amendments come in with the Constitution, and there have only been, there's been fewer than 20 since then, 3 of which came after the Civil War. So it's obviously a rare thing. It's very difficult to do, and that is somewhat by design. Okay, so that's the amendment process. The other important way that the Constitution really effectively does change is through something called judicial review, okay? Judicial review is the power of the courts, and most importantly, the Supreme Court, because of course you can't appeal beyond the Supreme Court. So the Supreme Court's decisions are pretty important and final, at least for the time being. So judicial review is the power of the courts when laws or executive orders or constitutional principles of the states or whatever are challenged. The federal courts, of course, can review them and determine whether or not they're constitutional. Okay. This power of judicial review is established by the Supreme Court in Marbury v. Madison. An early case in the early 19th century. But this constitutional review is very important. You're not formally amending the Constitution, but you are the justices, especially the Supreme Court. What happens is when they make a decision, they will have a decision will actually be written by somebody chosen, and you can have multiple decisions, but there's always one majority opinion, which is the official decision in the case, which explains the legal reasoning for why the court has voted the way that it has. Again, this is with the US Supreme Court. And that is very important because that's where they explain, the 14th Amendment means that this is unconstitutional. Or, something that wasn't entirely clear before now becomes clear and becomes an established, effectively a point of law through judicial review. And so that's a way that the Constitution doesn't necessarily change, but the meaning of the Constitution gets expanded, clarified through judicial review. So to take an example, Brown v. Board of Education, the Supreme Court says the 14th Amendment means that school segregation is unconstitutional. Okay, after that, we know the 14th Amendment makes school segregation unconstitutional. Before that, it was going on all over the place. After that decision, and now that didn't have immediate political effect, but after that decision, people's understanding of the Constitution is, okay, here we have this ruling, this authoritative ruling from the Supreme Court saying the 14th Amendment makes school segregation unconstitutional. It wasn't an amendment. There was no formal amendment saying segregation is now illegal, but there's an understanding of what the Constitution now says. So judicial review is not the formal amendment process, but it's a very important means by which we come to understand, at least temporarily, because sometimes, very rarely, but sometimes Supreme Court decisions can be overturned by the court later. But basically, it's a way that the Constitution gets, again, not really changed, but sort of expanded or clarified. And it's a very important way that our understanding of what the Constitution is, and therefore what is actually constitutional, what is legally and constitutionally possible, the way that that changes over time through these Supreme Court decisions, through judicial review, okay? So again, in terms of how the Constitution changes, that is an important part of it, and obviously far more common than the actual amendment process. That's far more common than the Constitution actually being formally amended by Congress and the states.